Well, to yesterday's High Court ruling, an important ruling in the High Court in Joburg yesterday, a judge saying that the bid by the Moti Group to try and stop the Amabhungane Centre for Investigative Journalism from publishing more information about them amounted to an egregious abuse of court process. Zunaid Moti and his companies had gone to court through an ex-parte process. In other words, they didn't tell Amabhungane, which meant the judge who made the first ruling did not hear the side of the argument from the journalists. Amabhungane says that they've been publishing information about Moti and his companies based on documents they received from a whistleblower. Moti claims the documents amount to stolen goods. The judge ruled there's a big difference between leaked information being used by journalists and stolen goods. Caroline James is the Advocacy coordinator at Amabhungane. Caroline, good afternoon to you. This is clearly a big victory for you.
Absolutely. I think for Amabhungane, yesterday's judgment felt like a complete vindication of all the arguments that we've been making since we received the ex-parte order served on us at the beginning of June, as it demonstrated, as you've mentioned, that the court found that the manner in which the Moti Group had gone about bringing this litigation was an egregious abuse of process, as well as affirming the media's right to publish information in the public interest.
We'll come back to the ex-parte thing in a moment, but the whole issue of whether this information is stolen goods, which is what the Moti Group claims, or whether it's in fact information which journalists should use. How important is that for you in investigative journalism as a whole? The judge ruling, of course, in your favour.
Absolutely. I think you're completely correct that it's important not only for us and for our reporting on the Moti Group, but for investigative journalism as a whole. And if the ex parte ruling had been allowed to stand, it would have impacted terribly on the ability of investigative journalists in the country to continue to practice their work. I think it's very key to note that the judge referred to other judgments and mentioned how it's accepted that an investigative journalist can be in possession of information irrespective of the manner in which that information was obtained. So as he said, even if he gave the Moti Group the strongest case that they were trying to bring, that the information had been stolen and that the person who had taken the documents was not classified as a whistleblower, even if those situations existed, which he didn't rule decisively on, then it still did not impact on Amabhungane's right to possess those documents and then to report on those documents in the series of articles that we have done so and will plan to continue to do so.
Okay, so in other words, what you're saying is it doesn't matter where the documents come from. Once the journalists get the information, it doesn't matter how it got there. It could come there from a competitor, it could come there from someone who's stolen, it could come from an ex-partner, whatever. You can still publish on it. That's how you see this.
Yes, I think the judge made it clear that the possession of the journalist is not unlawful, even if the original sort of getting of the documents was unlawful.
Okay. The dispute over the ex-parte application now, this is the sort of hearing on a Saturday where you suddenly received a court order, you hadn't been able to argue your side in this, and the judge, this is what the judge ruled was an egregious abuse of court process. What does that mean? Because there seemed to be a bid to basically stop you from publishing what's called a pre-publication ban.
Absolutely. So just to recap, the ex parte order that the Moti Group obtained had two elements to it. The one was that we were required to return all the documents within 48 hours, and the other was that we were prohibited from publishing any further articles based on those documents. In respect of the obligation to return the documents, as Judge Sutherland pointed out yesterday, that was completely impossible to do so in a process where we didn't have an obligation, have an opportunity our side. But as you say, in respect of the pre-publication ban, that is technically has been allowed in some cases in our law, but it is only in very extreme circumstances that a court will ban the publication of
seem to have lost Caroline James.
An article or a documentary published. It's a sort of extremely and are you still there?
Yes, we seem to have lost you there, actually, Caroline. I'm going to come back to some of these points, but I do want to ask, because the Moti Group has said through their CEO, Dondo Mokgajane, that in fact they're going to appeal this ruling, that they're pretty determined to appeal it. Do you believe they have any chance after what the judge said yesterday?
I mean, I wouldn't like to put words in any future judge's mouth, but I think that Judge Sutherland's judgment was incredibly clear, concise, and referred to multiple jurisprudence and examples from different courts that have ruled on similar situations. So I think his reasoning was incredibly solid and clear and concise and legal reasoning in his judgment. So we will obviously wait to see what the Moti Group does, but we are still
all right, I think we best
cautiously positive that any future court
would find
similarly.
Caroline James, thank you. I'm afraid that connection not working in your favour this afternoon. Caroline James is the Advocacy Coordinator at the Amabhungane Centre for Investigative Journalism. To other